Good morning, everybody, my young friends who are going to be the torchbearers of the law tomorrow. While entering this university, I found large posters of mine. I thought I was up for the parliamentary elections, and well, that startled me. Anyway, I don't have a ticket to Parliament, but what we are going to talk about today is the law and Parliament. That is, and the judiciary. We all have a ticket to the bar, to the judiciary. Tomorrow you'll have it. So we'll talk more about the interstitial articulation and judicial activism, which are basically judicial nuances and developed through the ages to develop the law. Given the proposition that the Parliament is supreme when it legislates, it is the prerogative of the Parliament to frame the laws of the country, and the judiciary just chips in. Why does it do so? When the Parliament leaves gaps, when the Parliament keeps a vacuum in the law, it is then that the judiciary has to decide. It has to decide because Parliament takes a very long time, extremely long, to amend the law. And Parliament, of course, as I go by, I'll show you that Parliament cannot explain itself. It cannot say that we meant this. It has got no power. And that I'll go by and show you. Now, this is what is where precedent comes in, where we have an interstitial articulation by the courts, where we have judicial activism. Now, look at this. If every age is modern to those who are living in it, now, something that is made about a century back, or maybe this century is about 24 years old, and we are living in modern times. Now, an act which is maybe made in 1900s. Now we are going through the motions. We are trying to amend the Evidence Act, the IPC. Now, suppose something that is not provided for. Will the act be stultified? It won't be stultified. It has to go on because law is organic. It moves. It is living. It is talking. So now here we are, and this is what Roscoe Pound says. This is very important, and this is where actually courts begin to legislate, where the legislature has had an intent and has sought to express it. There is seldom a question of interpretation. The difficulties arise in the myriad cases in respect to which the lawmaker had no intention because it had never thought of it. Indeed, it could never have thought of them. Because the legislature, when it enacts a law, it cannot apprehend everything that is going to come, all situations that might arise. And these are stitches. These are questions which come up before the courts. The courts have to decide then and there as to what the legislature meant. And that is how we have precedent. That is where we have another branch of law which is being developed by the courts. Though, of course, that is not codified. That is not codified law, but because of the fact that, and how does it get amended? It gets amended because a precedent can always be overruled by another. So the Supreme Court can also overrule its own decisions. Even the high courts do that. So now then, after that, the next point is, when the enactment does not express the intention clearly, expressly or completely, the court may embark on the task of finding the true expression, and this it does by A, finding and declaring implications used by the legislator. B, regarding the width or other obscurity of the language to elaborate the meaning according to one, public and legal policy, and the purpose of the legislation. So this is very important. Courts do not legislate in the air. Now, there has been a lot of criticism about judicial activism, about this stitching by interstitial articulation. People have said that you have gone beyond bounds. The courts are going beyond bounds. They have becoming uncontrollable. But that is good legislation. That is good articulation, which takes in account the public policy, the legal policy, and the scheme of the act. And as I go by, I will show you the legitimate judicial activisms which have taken place over the years, where precedent has, till date, held on. It's not been overruled. They are good laws. Now, here we are, the obscurity, and that is what we are talking about by stare decisis, binding on everybody. That is what the courts really develop. Now, why does the court always have to explain things? Why do the courts always have to interpret the law? Now, in England, it was said that no law was complete till it was interpreted by the courts. It had to be interpreted to put the gloss onto the legislation, so that a complete product is before all the agencies that enforce the law, including the administration. Now, the courts have to process. This is processual justice. Why do they do it? Why do they do it? Because of the fact that once the legislator or once the legislature has enacted a law, it becomes functus officio, means ex authority. You have no more power to tinker with the law. You cannot say, I meant this, not that. That is not up to the legislature. It is up to the court to intervene, to interpret that this is what was meant by the legislature. So now, interpretation postulates, now this is from a Supreme Court judgment. Please look at the screen. Interpretation postulates the search for the true meaning of the words used in the statute as a medium of expression to communicate a particular thought. The task is not easy, as the language is often misunderstood, even in ordinary conversation or correspondence. The tragedy is that although in the matter of correspondence or conversation, the person who has spoken the words or used the language can be approached for clarification, the legislature cannot be approached, as the legislature, after enacting a law or act, becomes functus officio, so far as that particular act is concerned, and it cannot itself interpret it. No doubt the legislature retains the power to amend or repeal the law so made and can declare its meaning, but that cannot be done. That can be done only by making another law or statute after undertaking the whole process of lawmaking. Statute being an edict of the legislature, it is necessary that it is expressed in clear and unambiguous language. In spite of the court saying so, the draftsmen have paid little attention, and they still boast of the old British jingle, I am the parliamentary draftsman, I compose the country's law, and of half the litigation, I am undoubtedly the cause. Now, it's not always that we can blame the draftsman because of the fact that, as I've said, we cannot, the legislature cannot anticipate the law always, or a situation always, a particular situation which we are living in. If everything is modern, then every person is modern, and situations arise which are typically modern situations typically modern postulates, typically modern problems. Now, the legislature is slow. It has to go through the motions. It takes years to put legislation into place, to enact it. So, what is the quick remedy? It is up to the courts to give the law, to interpret it. This is what is there. To take in the social changes. Now that would be contemporaneous expositive. Now we are not talking about contemporaneous expositive because of the fact that that is another subject on the matter. But then part of it, you can always say, because in interpretation, one thread runs into the other. So we cannot have really watertight compartments while interpreting the law or while applying the principles of interpretation. There are very thin lines which actually divide. Sometimes one runs into the other. So that is why now what I'm going to tell you is going to be organic, as I have said, that the laws are organic. And interstitial articulation, like interstitial tissues in your body, they lie within the covers. They bridge gaps. They connect. The tissues in your body connect each other. Now, that is what is implication. That is implied. Now, we say that much of the interpretation by the courts would be on implication, when you can't read it. What is underneath? What is the tissue that connects? That is very important. So when we are talking about this, let us go into this is what Crace says in his interpretation of the laws. He says, a statute is, now I'm always saying statute because the law cannot be a statue. It cannot keep on, it cannot, be a stone edict without life. It has to move on, it is organic. Now he says what he says. This is very important. A statute is divided into two parts, the letter and the sense. It is not the words of the law, but the internal sense that it makes the law. And our law, like all other, consists of two parts, the body and the soul. The letter of the law is the body of the law, and the sense and reason of the law is the soul of the law. Now, why does he say this? And why do I say that much of this interstitial articulation concerns the soul and the body? What we see is the letter of the law. What the court sees is the letter of the law. And then it goes into the sense, the real meaning that is maybe hidden, like an interstitial tissue. It's hidden, but it's there. And that is good interstitial articulation. That is good judicial positivism. Within the law, it is there. You have only to discover it, uncover it. And that is what implication would mean. That does it hold enough material? Is the law, is the statute, is the enactment good enough, substantive enough for us to conclude that it meant this also? So that the statute goes on. It progresses. Now, the intention of the legislature, it is the obscurity, uncertainty, or incomplete expression in the enactment that call for stitching the gap by articulation. The gap that is left, that is not apparent, that would stultify the statute, would have to be stitched. And that is how the act becomes complete. in its sense. Now, the intention of the legislature, which is not appropriately expressed, need elaboration by the courts by detailed propositions. These words are taken to have been implied in the statute. When the enactment is being applied to particular facts, it might be possible to restate the enactment in an expanded form to reflect precisely what the legislator would have said or the drafter has left unsaid. Now, this is what where the implication comes in. The articulation puts in the words that the enactment is taken as saying. Interstitial articulation is a technique by which relevant unexpressed provisions of an enactment can be expressed by filling out the interstices or gaps between the express words. The effect is that judicial expression is reduced to legislative form. This is another lawgiver. The courts are themselves lawgivers, one of the sources of law. So by stitching the gap, by interpreting, by saying what it is, what is implied in the statute, the courts identify particular instances and declare the law. Now, this is very important, concretization. I'm going to talk about this concretization. When Parliament makes an enactment, the meaning is concretized by judicial gloss or polished, by judicial interpretation to reflect the true legislative intent. The court is the finisher of the legislative product by polishing the statute. As far as interstitial articulation is concerned, in interpreting and applying the law, the judges create law in the many spaces not filled by Parliament. It introduces clarity in legal reasoning, and the judges actually declare explicitly the implied and unexpressed provision in the statute. The judicial authority articulates what seemed to them to be the appropriate version of the statute. Within the verbal interstices provided by the express wording of an enactment, there can then grow, decision by decision, the concrete details needed to spell out its meaning in particular cases. Now, if you've understood this, this is talking about precedent. This is talking about stare decisis. Because by precedent, the law is created inch by inch. Particular situations, particular pronouncements on different aspects, maybe of the same enactment, maybe of the same cases. So this is what actually the court does. Look at the next slide. Sometimes there are authorities to say that casus omissus, that is, what is not spelt out by the Parliament or by the legislature, should not be filled in by the courts, and that you have to give effect to the literal meaning of the words that have been used in the statute. Now, here, what does Lord Denning say? He was fond of progressive interpretation of the laws, dynamic processing, which is now in vogue. But he was one of the first people who thought that law should be, he was there, and Cardozo was there. These people were thinking about a progress in the law, that it should not be stultified by hands-off policy by the courts. Now, Lord Denning saw that the literal meaning of the words were correct, but that led to nothing, practically absurdity. So what he said was, to give effect to the act, you need to do a bit of adjustment, necessary to do a little adjustment so as to make the sections workable. Like I said, the act could not be put into maybe a showcase and locked up. And we wait for a millennium for the legislator to wake up and say that we need to change the laws. So the courts have to stitch in. They have to walk into it and make the imputation, that is, the implied conditions that are there, ripe in the statute itself, they bring it out. The obscurity is removed and polished and completed. And between the express words, so that it makes a cohesion, a whole. Now, there was this case where, under the Maintenance and Welfare of Parents and Citizens Act, now we have got this act for our protection, we senior citizens, you cannot drive us out of our houses when we own one. This was, the mother was driven out of the house by the son. And the mother then went to the subdivisional officer asking that her house be given back to her and the son be evicted from the house. Now, she won the first round, and then in the tribunal, she got an order for herself. But the tribunal ordered that the subdivisional officer raise a posse of policemen and drive the son out of the house and give her possession. She came up, she did not, her son came up before the High Court complaining that this was without jurisdiction, this order was without jurisdiction because of the fact that the act did not empower the tribunal to say that by police force you drive the son out of the house. The writ petition failed because of the fact that the courts, the High Court, depending on another judgment of the Supreme Court, said that this was ancillary. This power was always there to give effect to the provisions of the Act. It could not be stultified. It could not be standing still at a place, and you could not ask the mother to go and file an eviction suit against the son to enforce the order of the tribunal. Now, this is what it said. This was quoted before the High Court, and this is an unreported judgment. Of course, I lost a lot of fees because the writ petitioner never went up in appeal. But anyway, I had to contend with the winning of the case. Anyway, let's read what has been cited here. Where a statute gives a power, such power implies that all legitimate steps may be taken to exercise that power, even though these steps may not be clearly spelt out in the statute. Where the rule-making authority gives power to a certain authority to do anything of public character, an authority should get the power to take intermediate steps in order to give effect to the exercise of the power in its final step. Otherwise, the ultimate power would become illusory, ridiculous, and inoperative, which could not be the limited intention of the rule-making authority. In determining whether a power claimed by the statutory authority can be held to be incidental or ancillary to the powers expressly conferred by the statute, the court must not only see whether the power may be derived by reasonable implication from the provisions of the statute, but also whether such powers are necessary for carrying out the purpose of the provisions of the statute, which confers powers on the authority in its exercise of such power. So as I was talking about, it says that it cannot be ridiculous. You cannot say that you cannot do this and go somewhere else. That power is always there. Incidental power. That surfaces. It has to give effect to the act. That the parliamentary draftsman did not say, or Parliament did not think about it. So this is how the gap is filled in. And this is purposive construction. And this is interstitial articulation by the court. This is lawmaking, but lawmaking in a limited sense. Very little. Just the gap. Small. Almost invisible. But that is there. That has to be filled in. Now, there was another case. This is a celebrated case under 125 of CRPC. This is Captain Ramesh Chandra Kaushal. Now here, under the CRPC, under section 125, it gave power to the magistrate to award about 500 rupees to the wife, to the estranged wife, for her maintenance and that of her children. Now, the wife, estranged wife, came up before the court and said, look, this is a pittance. I can't maintain my family like this. It must be 500 rupees apiece. So the court, the Supreme Court, and Krishna Iyer, in his inimical, intimidatable style, he says that, yes, of course, it is a pittance you must have. In his flamboyance, he says this. Now, if a woman has a dozen children and the man neglects the whole lot, and in his addiction to a fresh mistress neglects even his parents, and all the members of the family seek maintenance in one petition against the delinquent respondent, can it be that the court cannot award more than 500 rupees for all of them together? On the other hand, if each filed a separate petition, there would be a maximum of 500 rupees each awarded by the court. We cannot therefore agree to this obvious jurisdictional iniquity by reading a limitation of 500 rupees all through, although what the section plainly means is that the court cannot grant more than 500 rupees for each one of the claimants. Now that was limited to 500 rupees to the claimants, each of them, not to the whole. That is how in the whole has been interpreted. In the whole, in the context, means taking all the items of maintenance together, not all the members of the family put together. To our mind, this interpretation accords with social justice and semantics, and more than all is obvious, it is sometimes more important to emphasize the obvious than to elucidate the obscure. We admit the marginal obscurity in the diction of the section, but mind creativity in interpreting the provision dispels all doubts. We own that judges perform a creative function even in interpretation. So what he was stating as interstitial articulation, he was saying that I'm just stating the obvious. It is under the surface. It had only to be uncovered. And it was there in the Act. It is there in the policy of the Act. It is there for public policy. It is there for social justice. So this is the interpretation that has to be given. And this is beneficial legislation. So it has a far wider amplitude. When you 125 CRPC is beneficial legislation to prevent vagrancy. So that would also need very liberal interpretation. Now, what are the advantages of interstitial articulation? Help the parties in considering whether to bring or resist an appeal, and if an appeal is brought, the appellate court has advantage of deciding whether the court below had erred in its construction of the enactment. Secondly, the articulation clarifies the relevant provision of the enactment from then on as a precedent, assisting lawyers, litigants, and those who administer the law to expound or alter the enactment in question. Now that is the advantage of it. Look at this spire here, spire. You would find a cousin of it in Belgium, from where this replicas of the Calcutta High Court has been taken. It's a fine piece of sculpture, fine edifice, still standing from 1862. Now, how does the legislator or the legislature, how do they react to a pronouncement, a declaration by the court? They either try to overhaul it by fresh litigation, by removing at times the objection that was before the court that was declared as ultra vires or that was declared as illegal. It removes the legislature removes the objection or brings in a new act, amends the old one, or amends a portion of it, and clarifies its stance that this is what we want to say. Like I said in the first in the beginning of the talk, that it has to do this throughout. So now, where Parliament does not intervene to reverse or modify the glossing of the statute by the court, it can be taken as tacitly approving the declaration. It is an indication that the legislature is satisfied with the court's ruling. So no more is said, we accept, that's fine, as that's the law. And there have been cases after cases, like the one I was talking about, 1978 Supreme Court, that is so many years old, it still holds the field. Now, what is judicial activism, basically? We talk a lot about it, judicial activism. This is not right. That we all hear a lot of criticism about it sometimes, and sometimes rightly so, and sometimes wrongly so. Now, judicial activism is a facet of interstitial articulation, though the caveat is that the power available to the judiciary is limited and can be exercised only in the gaps left by Parliament. Creating a new law which is not contemplated by Parliament is not a part of judicial function. Now, I have said that while dealing with a particular statute, the courts have to look into the policy, the court has to look into the scheme of the act, it has to look into the legal aspects, and then pronounce judgment on it. So that it becomes complete. Now, if the courts were doing something else, like suppose your cricketer is allowed to polish the ball on his trousers, but if he was tampering with the ball, then, of course, that is illegal. Now, you cannot tamper. You cannot make a law which Parliament has never contemplated. This is not even necessary for you to pronounce judgment on. So that would be bad judicial activism. What would be legitimate judicial activism would take into consideration the policy, the principles, the scheme of the act, and then stitch up the gaps and say that, yes, according to us, this is correct, this should be done because of the advancement of age, advancement of society. That takes care of the organic development of the law. Now, Benjamin Cardozo, as I've said, he was one of those who proposed that he was not averse to overruling and of judgments, and he was also espousing the progressive development of the law. He quotes from another author, and he says that the law needs to act far more quickly than it does in recognizing and giving effect to new business institutions as they arise. Now, he was talking about America, which was in the 50s, and where everything was developing. So he talks about this, and this is very important, because now we are also facing such a situation in this country. It needs to permit those institutions far greater flexibility than at present in the modification from case to case of their lesser detail. It needs to do both of these things with an earnest view to the economic functions and not to the legal incrustations of the institutions concerned. And the restatement of the law to satisfy business needs must work, and work vigorously towards these ends. Bring in a new law, or interpret the law in a modern sense to give effect to it, so that everything progresses. You need not have new laws always. The old law can also be interpreted in the way so as to bring in new thoughts. There was a book by Subbarao, one of the great Supreme Court judges. He once said that we need not continuously amend the Constitution because it is an organic legislation, and everything is there. We can just interpret it in a contemporaneous way, so that the motions of putting it before the Parliament and continuously changing it is not necessary. That was once what he said, but that may not be true really, because we cannot interpret the law like that sometimes. We cannot put in new laws. The courts are incapable. That would be without jurisdiction. That would be beyond their jurisdiction, because all courts are courts of limited jurisdiction. We have Article 141, but 141 itself is a restraint. It is there. I'll be going on to say that. I'll be discussing this issue. But 141 of the Constitution and 142, which says that you can do complete justice between the parties. And 141 says that the law declared by the Supreme Court it binds everybody. Now, what is the law that is being declared by the Supreme Court? It is not statutory law. It is a precedent. It is stare decisis. That the particular case has been decided this way. And what is binding on us is the ratio of the decision, the principle on which that particular declaration has been made. So this is what it actually is. Now, judicial activism has come under a lot of criticism by jurists, by great jurists, and this is, but this, I think, is the basis of legitimate judicial law, a law created by the judiciary. This is the basis. Now, this is Salmond, and everybody's heard about Salmond, the great jurist. We must distinguish lawmaking by legislators from lawmaking by the courts. Legislators can lay down rules purely for the future and without reference to any actual dispute. Underline those words, without any reference to any actual disputes. This is when the dispute comes in, then the courts come in. The courts, insofar as they create law, can do so only in application to the cases before them, and only insofar as is necessary for their solution. Judicial lawmaking is incidental to the solving of legal disputes. Legislative lawmaking is the central function of the legislator. So, prerogative of the legislature is to make the laws. It is not the prerogative of the courts. But what the courts do is that they pronounce judgments. They declare the law on the point when there is a dispute before them. It's that stitching. They have to do it, and they have to do it because of the fact that the legislature will never have a machinery which can work fast, which can immediately, where we can just email, oh, what did you mean by this? And in comes the answer, I didn't mean this, I meant that. That the legislature cannot do. And the only institution that can do it is the judiciary. For one thing, now this is another jurist, you've heard of him, Professor William Wade. He's very famous for his work on administrative law. And this is what he says. He was writing a paper on the Indian judiciary and democracy, judicial activism and constitutional democracy in India. And he was saying one thing. For one thing, courts lack the facilities to gather detailed data or to make probing inquiries. He was against creating of the law like that. Reliance on advocates who appear before them for data is likely to give them partisan or inadequate information. On the other hand, if courts have to rely on their knowledge and research, it is bound to be selective and subjective. The Supreme Court could well have left the decision-making to the other branches of government after directing their attention to the problems rather than itself entering the remedial field. Now, Professor Wade, with great respect, is saying the right thing maybe, but also he's a bit tight because of his work on, he believes in ultra-vires, the policy, his principle of ultra-vires, where he limits, we have in administrative law, he's always limiting the jurisdiction. So here he was subjecting the courts to a jurisdiction. He says the Supreme Court should not enter the remedial field. But if the Supreme Court does not do it, then Article 141 becomes redundant. And the High Courts, also under Article 215 of the Constitution, where it is a court of records, they lose their sting. They cannot create a precedent. So he was also, I think, conformed by, he was thinking of the English judicial system, where the High Courts and the Supreme Court, they cannot strike down any legislation. Here, of course, the Supreme Court and the High Courts have the power to strike down any legislation which is not constitutional, because we have a written constitution. But I may not be correct also. But this is what I think would be limiting, really limiting, when he says that you cannot enter the remedial field. Then what is the court going to do? It is going to make an edict of the statute and freeze it and put it in a refrigerator and forget about it. That's not going to be really true, because it's not organic, it's not moving. You have to move it. So that would be, and then, of course, another jurist, he also criticizes this judicial lawmaking, judicial pronouncements, which are actually judicial activism by the courts. Now he says this, but he is really not wrong, and I will not say he's wrong, because there have been cases where there has been treading of paths where the Supreme Court should not have done it, with great respect, and they have been overruled. They have been overruled. So, and I'll be soon dealing with cases where the Supreme Court has legitimately entered the field of judicial activism, and where it has illegitimately also entered that field, and where the courts had to, again, redo the wrong that had been perpetrated. Now, directions are either issued to fill in the gaps in the legislation or to provide for matters that have not been provided. This is Professor Sathe. Have not been provided by any legislation. The court has taken over the legislative function, not in the traditional interstitial sense, but in an overt manner, and has justified it as being an essential component of its role as a constitutional court in a strict sense. These are instances of judicial exorcism that fly in the face of the doctrine of separation of powers. While lawmaking through interpretations and expansions of the meanings of open-textured expressions such as due process of law, equal protection of law, freedom of speech and expression is a legitimate judicial function, the making of an entirely new law through direction is not legitimate judicial function. Now, this is the right sort of criticism. The court it cannot create a new law. It cannot legislate. So this is what he's saying, and he's absolutely correct. Now look at this. The answer to it is this. The very existence of parliamentary sovereignty might be considered to remove the sting from certain criticism of judicial activism, since the sovereignty doctrines ensures that any such activism notwithstanding, Parliament retains the final word. Now this is Andrew Burrows. He was speaking in the Hamlin Lectures in 2017 before the Cambridge University, and this is what he says. Now, one of the instances of judicial activism would be the case of Maneka Gandhi. Now, that I'll go to. The next slide, please. Secondly, very commonly, the issue in relation to the development of the common law is not once that the legislature is going to take forward. This is the anxiety as to why the law has to develop. Time for legislation is tight. It doesn't have much time. So if the courts do not take forward the reform, that usually means in practice that is the end of it. That would be like stultifying the statutes altogether, or the progress. In other words, it is disingenuous to say reform is better left to Parliament when in reality it is almost certain that Parliament will do nothing. So there are situations, small things, small acts, they don't go to Parliament. They don't, small little changes, which sometimes becomes necessary, they don't go to Parliament. Parliament has no time for it. It is too busy. So the courts, they have to do the stitching. They have to pronounce judgment. They have to declare the law. And to tell you very frankly, very small propositions of law become big propositions when they go up to the Supreme Court, because they tend to become national issues at times. And because that is a pronouncement which is awaited to give effect to the real sense of the statute. That is important at times. I was told once by a very senior person that these small issues become very, very big issues, and they need to be resolved. So when you go through the judgments of the courts, when you go through your reports, you might see that there are very small things which matter. And this is one of the small things which becomes a very big thing. Now, I'm going to talk about this. This is Maneka Gandhi's case. Now, the 1967 Act of Passports Act, it allowed the impounding of a passport of a person without even thinking of him, or without even giving him an opportunity of being heard. Now the courts, this went up before the courts, and the court said, no, this cannot be done. The courts said that, okay, it is not in the statute itself, because the 1967 Act said nothing about natural justice. It provided nothing. It provided no hearing. There was no provision. So the court said, no, it has to be read into the Act. Then the question of giving a hearing, a reasonable opportunity to the person whose passport is being impounded has to be first heard before you impound his passport. And that is ingrained in the Act. Now, this is one of the cases where which is legitimate, absolutely within the scope of the Act, and the obscurity is removed, and stating the obvious. We've noticed that before in Krishna Iyer's judgment. Now, this is what judicial activism would be. A long course of, now this is what the Supreme Court, basically it's a very big judgment. It runs into lots of pages. and Article 14 is considered, Article 21 is considered, and but the basic is natural justice, where this is ingrained in the statute, because the court says that Article 14, Article 21, they are violated. When you just impound a person's passport without saying a word. Now, a long course, this is what actually influenced the court, a long course of decision, beginning with Dr. Bentley case and ending with some recent cases, established that although there are no positive works in the statute requiring that the party shall be heard, yet the justice of the common law will apply to the omission of the legislature. And so he has to be heard. So this is where judicial activism was at its best. And I'm not talking about the MC Mehta cases. Those were the cases where a new direction was given to environmental law, where stitches were made, where the Supreme Court declared the laws and protected the environment, to protect the environment. So that is something which is always hidden under the skin, and which has to come up for remedial justice, number one. Number two, for social justice and to protect the environment. So those MC Mehta's cases are very well known, and so we need not deal with them. Now we'll deal with another case which comes up before us, a new case where the election commissioners had to be appointed, and the government was doing nothing over the years, none of the governments, to elect them. And there was a constitutional silence. So this is Anup Barnwal versus Union of India, 2023, 6 SCC. Now, where there exist veritable gaps or a vacuum, the court may not shy away from what essentially would be part of its judicial function. When there is constitutional silence, the court came to the conclusion that no law, however, came to be enacted by Parliament to put things into place. As I said, that Parliament, you've seen Andrew Burrows, he says, Parliament will do nothing about it. Now, this is one of those cases. We have elaborately referred to the noises and voices eloquently and without a discordant note being struck, which points to an overpowering symphony which calls for the immediate need to fulfill the intention of the founding fathers. Election, now it's in the offing, is a very important thing for all Indians, and therefore the courts thought that they should intervene to give effect to the constitutional mandates that were implied. Now, when I conclude, I'll tell you, this is the last, and I hope I have kept you awake, because topics of this sort tend to put people to sleep. I've kept my promise. I'm just hurrying through so that I can see the faces, at least, up, not slumbering. Anyway, but you will be well within your jurisdiction to sleep if you want to, but snoring might just disturb. So keep your handkerchiefs and just go on sleeping. But then, now let me finish. Through one agency or another, either by statute or by decisions, rules, however well established, must be revised when they are found after fair trials to be inconsistent in their workings with an attainment of the ends which the law is meant to serve. So this is the end. Everything is, what is the law meant to serve? The revision is a delicate task. He is alive to the fact, Cardozo, not to be undertaken by gross or adventurous hands, lest certainty and order be unduly sacrificed. Yet a task also not to be shirked through timidity or sloth. Now, if the courts were shy, if the courts were lazy to pronounce judgments on issues which are of public moment, which, of course, would advance civilization, which would advance the social growth, or maybe anything like that, then that would not really be the rule of the courts. It has to take it, but it is a delicate balance that has to be struck as to whether to do or not to do. It's like sometimes the courts are faced with the problems like Hamlet, to be or not to be, to do or not to do. So sometimes you'll also see that cases are dragged on because the court is sloth, it is slow. So adjournments after adjournments, date ke upar date. But that is when you are defending the case. I will not say that courts are really inclined to give adjournments very easily. Now it's becoming even stricter because of the piling up of litigation. So that is, if the law is to be organic, if it is a government of the living by the dead, this is what Spencer said, Herbert Spencer, then it has to be purposive, it has to be dynamic. It has to be move on. So I have now finished my lecture, and we'll strive to please you every day. That's from 12th night. So that's what we are doing to my lords. We're trying to please them every day so that we get judgments. Thank you. Namaskar. You have any questions? I'll try to answer them. Not that I sometimes might make I just might pass it over if I don't know it. So if you have any questions, you can put them on.
us by.
Oh, thank you. Oh, my God. Oh, thank you, thank you. Thank you, everybody.
And I would also like to thank Professor Surudeep for organizing such a well-planned lecture for all of you. He's been working very hard, understanding the dynamics of the events in the logistics of events in Jindal Global University. And last but not least, all of you, thanks so much for coming. Hope you had a good time, and we'll see you again in the next guest lecture. Have a great day, everybody. Tea and snacks are being served outside, so please join us for that.